Good morning, everyone. Thank you very much for tuning into this webinar. My name is John McLeish, and I'm going to be chairing the panel today. The format is going to be that the lawyers will talk on a particular topic for approximately 5 minutes, and then we're going to ask some questions among ourselves about the current issues of the day, and then we'll take some questions from you. So as we're going through this, if you have any questions, and you'll see in the top right part of your screen, there's a box there where you can send in questions, so please feel free. I can take them on the computer here. We're going to go till about 10:30, and now I'd like to introduce some of the panel members. To my immediate left is Kimberly Barrett, and she is an accident benefit specialist with Oatley Vigmond, and she works on Roger's team. And just to her left is Jim Vigmond, who probably all of you know, or most of you know. Immediately behind me is Loretta Russo, and she is with McLeish Orlando, and she works on Pat's team. To Loretta's left is Pat Brown. He is a partner at McLeish Orlando. And then to Pat's left is Troy Lehman at, of course, Oatley Vigmond. We're going to cover 4 major topics, but as I say, we'll take your questions. And those topics are incurred expenses and economic loss as they relate to attendant care claims, and Pat is going to deal with them. I'm going to deal with recent developments in catastrophic impairment, and specifically the mental and behavioral disorder aspect of catastrophic impairment. Troy is going to deal with common pitfalls in clinical note-taking and report writing. And finally, Jim is going to talk about preparing to give evidence at a trial or a FISCO arbitration. So without further ado, we'll start with the first topic, and that's incurred expense by Pat. And as I say, Pat's going to talk for approximately 5 minutes. Pat?
Great, thanks, John. On the topic of attendant care and incurred expense, it's an important topic, as we all know, especially as it relates to family members providing the care to the injured person, since the majority of injured persons do prefer to have family members provide that type of personal service. 2 cases I'm going to talk about briefly today, which I believe set the boundaries for what is an incurred expense as it relates to a family member, is the Henry versus Gore decision, which was a 2012 decision, and then the Simser decision that followed it shortly thereafter. In the Henry decision, Mr. Henry was catastrophically injured, and his mother wanted to provide services to him and took a leave of absence from work. At her workplace, she was earning approximately $2,100 per month, and as a result had left that and began to look after her son. Because the individual was catastrophic, the Form 1 was at about $9,500, but it was capped off at $6,000 for the attendant care. Gore, the insurance company, argued that they wanted to pay her $2,100 or $2,117 per month, which was somewhat quantified based on her own loss from work. And of course, the injured person, Mr. Henry, argued that he ought to be entitled to the $6,000. So it came down to this issue as to whether or not you should be quantifying the actual loss of the person, the provider, or the family member that has left their employ. And Justice Ray held in that particular decision, when he took a look at the section, that you do not take into account the provider's income, but you should only consider whether or not, as in this case, there was an economic loss suffered. And so when he made his decision, he went back and said, firstly, on an incurred expense, so long as it's paid an expense, or you're legally obligated to pay it, or there's a promise to pay it, you meet the incurred definition. But when it came down to sustaining an economic loss, he said that was not defined, and therefore if you can establish that there's an economic loss, then that should suffice, and you do not need to go into the quantification of the actual loss to the provider. Following that decision was the Simser decision, a different result. In this particular decision, Kathy and the Simpsons were providing services of attendant care. And in that decision, it was argued by the injured person that when determining whether or not you have this economic loss, you can look at a broad and liberal interpretation. And they brought in an economist to give evidence, Professor Carr. And his evidence was to the extent that if there's lost time away, then that can equate to an economic loss when you give it a broader interpretation from an economist's viewpoint. And they actually said, well, that's too broad. And in fact, in order to have an economic loss, you need some kind of financial or monetary loss, and it has to be quantifiable to a certain extent. So from that standpoint, the two individuals that were making the argument, one had argued that they had lost overtime hours, they were working less, and therefore that equated to an economic loss and should suffice. And in that particular decision, they held that it did not. There was no evidence that was called showing the financial loss. There was no documentation or pay stubs from the employer or anything to give rise to the actual loss, and therefore it wasn't allowed. To the same extent, the other provider argued that they were no longer able to attend at school and there was lost time at school, and that equated to an economic loss. And in the particular decision, they said that there was no evidence of the person, how the missing of school affected the individual, and there was no evidence of an academic plan or potential loss, and that in that particular case, the person never testified. So from that standpoint, they found that no, there was no economic loss established, and therefore the incurred expense test was not satisfied. So what do these cases tell us? I believe they tell us two things. You need a loss, but it does not need to be more than the benefit itself. As long as there's a quantifiable loss, as long as it's specific, quantifiable, not abstract, and not hypothetical, then it's something that will be given consideration. The key to it is obviously calling the proper evidence, having the proper documentation of the loss so that that quantification can be done. And so there's different examples that you should consider. You get examples such as a working mother who needs to hire a tutor to teach the kids when she's going to the hospital, and she hires that tutor. Obviously, you'd want to show the actual loss, the expense being paid. If you have a stay-at-home mom and the husband's in the hospital, the wife cannot get the work done because she's at the hospital. She hires a housekeeper. That potentially could be an economic loss. Again, establish the evidence, show the invoicing, show the payment being made. And you get different types of examples, but the key to these cases is obviously calling the proper evidence as well.
Thank you very much, Pat. I'm going to talk now about some recent developments in catastrophic impairment, and as I said earlier, I'm going to talk about mental and behavioral disorder. I've got a PowerPoint here which I would like to refer to, and this all relates to the Court of Appeal decision in Pastor and some subsequent cases following Pastor. So what is before you now is the mental and behavioral disorder chart, part of it as it appears in the AMA guide. So I'll just explain the chart ever so briefly. Down the left side of this chart, there are different areas or aspects of functioning, and there's 4 to be specific. And you can see them there. The first one is activities of daily living, social functioning, concentration, and adaptation. And then, of course, there's the different levels of impairment, starting with Class 1, no impairment, all the way up to Class 5, extreme impairment. And for a person to be considered catastrophically impaired, there has to be at least a Class 4 marked impairment. So if there's a Class 4 or Class 5 impairment, the person is considered catastrophically impaired. And then there is the full chart. Class 4 is impairment levels significantly impede useful functioning. The AMA guide elaborates a little bit on the different areas or aspects of functioning, with respect to activities of daily living, that includes self-care, personal hygiene, and some other things. With respect to social functioning, that's simply the ability or capacity to interact appropriately and to communicate effectively with others. And then concentration, ability to sustain focused attention long enough to complete everyday household tasks and permit the timely completion of tasks at work. And adaptation, ability to adapt to distressful situations. So that is the chart. One thing that, or the main thing that the Court of Appeals said in Pastor is, just to go back, you do not need all four or several areas or aspects of functioning. Simply one will do. And then the Pastor case talked about the methodology that assessors must go through. It's a three-stage process in a determination of what level of impairment the person is at. Firstly, whether or not, the first step is whether there's a mental disorder. Second is the impact of the mental disorder on the person's daily life. You identify that. And then, of course, the last stage is the degree or severity, and that's determined by looking at the four categories. And as I said, the person's got to be at least a class 4 marked impairment. So that was Pastor, and there's been at least 3 cases that have come out since Pastor. And one of those cases is called J.M. versus State Farm, and I'll just talk about it ever so briefly. In that case, a 50-year-old man suffered a fracture of his right fibula, an ACL tear, a right medial meniscus tear, and he had some depression and chronic pain. And he was considered catastrophically impaired, and he met it based on the mental and behavioral disorder in 2 areas. One was activities of daily living, and the other one was concentration. So there's 2 ways he met it right there under mental and behavioral disorder. And he also met it yet a third way, and we call it the 55% rule in our office. It's the 55% whole body impairment. That's one of the cases. There's another case, Muchku versus State Farm, and this involved a rear-end collision. The individual did not attend the hospital after the collision. She only went to her family doctor 5 days after the collision. She had a pre-accident health history of depression, and her family life was very tumultuous. For example, after she immigrated to Canada from Russia with her husband and 2 sons, one son was convicted of murder sent to jail. Her other son was shot, and she, notwithstanding all of that, was found to have suffered a mental and behavioral disorder, and based on the Pastor decision. And the importance of that case is there was a lot of inconsistent evidence, and the lesson that we lawyers take from that is just prepare the client to make sure that what she says is consistent with the records, and her evidence was all over the place, but notwithstanding that, she still made it based on a mental and behavioral disorder. And the last case I'm going to talk about is MG versus Economical, and that was another one of these cases involving depression, anxiety, and chronic pain. And there was some lingering concussion-like symptoms with this person. She was a 55-year-old registered nurse. She had made 3 attempts to go back to work, all unsuccessfully. And The insurer economical took issue with the fact as to whether or not she was catastrophically impaired or not, and she made it on 3 out of the 4 areas of mental and behavioral disorder. And one of the factors that the arbitrator looked at in that particular case was just the importance of corroborating her evidence with lay evidence as to the impairments that she suffered. So that's an update on mental and behavioral disorder. And who's next? Is it? Take it away, Troy.
We're preparing for a number of trials in our office that are scheduled to start in May, and one of the things that we do when we're preparing for a trial is to pore over and stress about everything that's in the clinical notes and records and everything that's in our experts' reports. And over time, you see a number of pitfalls that people run into when they're putting together their clinical notes and records, and a number of pitfalls that people write into expert reports. And I'm going to talk about 4 pitfalls with respect to clinical notes and records, and 4 pitfalls with respect to expert reports. But before I get there, let me just distinguish between the two. Clinical notes and records are records kept for treatment purposes. They're intended to refresh the memory of the person who's writing them, and to educate other treatment people who read those records with respect to history and findings. They're really intended for treatment. Expert reports are something completely different. An expert report is when you're asked by a lawyer, as part of a case, to offer an opinion on an issue in the litigation. And expert reports have to comply with the rules of civil procedure that set out what needs to be in a report. So let me start with the pitfalls that we see with respect to clinical notes and records. The first one I want to talk about is legibility. With respect to handwritten records, we sometimes struggle to read them. And there's nothing more embarrassing for a treatment person who's on the stand in a trial when they're asked to read their handwritten note and they can't read it themselves. That's a problem. It's also a problem when other people are relying on your reports to educate themselves about the patient because they're relying on your notes for treatment purposes, and if you can't read them, there's an issue with respect to care. The second pitfall with respect to clinical notes and records relates to the completeness of charting. You're not able to chart anything, everything, but you have to be careful to make sure you do chart all of the significant information that you base your treatment on. Because if there's ever an issue about your treatment, the law is pretty clear. There's been a number of cases where the treatment provider does not have a note, the patient has a recollection, and the patient's recollection will almost always trump the evidence from the treatment provider with an incomplete note. The third pitfall with respect to clinical notes and records relates to imprecise language, and we see a lot of this, particularly when we're reading hospital records. Notes like John was observed resting in his bed comfortably. Jim was speaking inappropriately towards the nursing staff. Michael is doing better today. What does that mean? Doing better as opposed to what? It's important to be precise and not fall into that trap of using language like that I just mentioned. The last pitfall with respect to clinical note-taking relates to what I would describe as irrelevant commentary, and we do see some of this. The only opinions that should be in clinical notes and records are opinions that are relevant for treatment purposes. And I'll read you just a couple of examples of opinions that we've seen in clinical notes and records that have nothing to do with treatment. So here's one from a psychologist. The case manager taking him to family doctor to get antidepressant medication with 2 exclamation marks and then in brackets, presumably to help the lawsuit. That's an opinion that has nothing to do with treatment and really shouldn't be in a clinical note. And then another one, mom says going to court now, lawyers will try to settle before court something like $2 million. That's a real note that's in a clinical note and record. And again, it's completely irrelevant from for treatment purposes and can cause all sorts of problems for a patient. So moving to expert reports, I'll quickly go through the 4 pitfalls we see there. When you write an expert report, you need to comply with Rule 5303, which sets out everything that has to be in an expert report. You need to read it before you write a report. You've got to set out all of your reasons, all of your factual assumptions, all of your analysis. Everything is spelled out in that rule. If you need a copy of the rule, send me an email and I'll happily send it to you. Make sure you read it before you write an expert report. Number 2, you've got to avoid writing like an advocate. You've got a duty when you're offering an expert opinion to be impartial, fair, nonpartisan, and judges are looking closely at what treating people in particular write. And if you write things in an argumentative way or in an inflammatory way, that's going to be a problem, and your evidence is not likely to be accepted because you're going to be seen as an advocate rather than a fair expert. The third thing we sometimes see with respect to expert reports is people offering opinions that are outside their area of expertise. So if an occupational therapist, rather than talking about function, talks about medical causation, we sometimes see that. That's a problem. And Justice Strathy said in a recent case, the willingness of an expert to step outside his or her area of proven expertise raises real questions about his or her independence or impartiality. So stay within the area of your expertise. And then the last thing with respect to expert reports that is important to remember is to be critical of facts that you're given. If you're dealing with a person with a brain injury, for example, it's important to go outside and get collateral information from family members or other sources rather than to accept what they say. To review the documents that are available to you, and if you don't think you have the documents that you need to be critical, ask for them. And I'll just end on that. If you've got any questions when you're writing an expert report that you've been asked to write by a lawyer, don't be afraid to pick up the phone, call the lawyer and ask the question before you write the report.
Thank you very much, Troy. Our last major topic is by Jim Vigmund, and it involves everyone's favorite pastime, listening, I know, and that is preparing to give evidence in the courtroom. Jim?
There is nothing more exciting, and you should embrace nothing more than giving evidence in front of a jury in particular. It's a real high, and you should all look forward to it. And I know half of you or 3/4 of you are trembling at the thought of it, and the other part of you are embracing it. I start with dress, and I always tell the witnesses to dress business casual, but that means different things to different people. I had one case where a dentist in a TMJ case wore a Hawaiian shirt, and that's all that he had. He didn't have a jacket. The only thing I could do was tell him to button it up. Another woman I had was a personal trainer, and she wore her spandex personal training suit, and that was business casual to her. So I think you have to address that. Please dress business casual. The most important thing you have to understand is, why are you being called to testify? It's often not about any opinion that you may have. It might be things like, is the client motivated when he comes for his physiotherapy treatments? Does the client listen to my suggestions regarding nutrition, if you're the nutritionist? Ask the lawyer, really, why am I testifying? You'll have a better comfort level, and if you have a better comfort level, you'll come across as more sincere. You're within your skin. You're not trying to testify about anything you're uncomfortable with or that is in any way controversial. Make sure that you actually sit down with a lawyer before you testify. We generally will get witness statements first from one of our clerks. That way we've cut out some of the fat. We know what we can hone in on, and then we'll want to meet with you usually before the day of your testimony. If it's really short and uncontroversial, we may just meet with you over lunch or in the morning before the evidence starts. The most important thing that you can otherwise do to prepare for giving evidence is be fully familiar with the file. Please make sure that you've read every single entry that you have in your file, whether it's your own entry or whether it's somebody else's entry. You'll want to ask the lawyer what you will be asked in cross-examination so that you can prepare. That is something that you have to arm yourself with, again, the whole idea for you is to feel comfortable in understanding what it is that you're going to be asked by your own counsel, what opinions you may be asked under cross-examination. You do have a right to know when your evidence is to be given and for how long it will be. Unfortunately, more often than not, your evidence will be rescheduled because sometimes evidentiary issues arise. We don't know when they're going to arise. That means that we have to have argument, which delays the process somewhat. Sometimes we have a hard time predicting who is going to be how long. So those are the kinds of things that you'll have to address with counsel. And the last thing that I would say in preparing to give evidence is it's really important for you to listen to the questioner and to the question. You can't start or shouldn't start your answer, and this is perhaps an obvious point, but it happens more often than not. You can't start your answer until the questioner has finished asking the question. And if at any time you're having difficulty understanding where he or she is coming from, you just ask. So be comfortable. The best preparation you can do is read your file, be familiar with it, talk to counsel, get an idea of what it is you might be asked in cross-examination, and understand why you're there.
Thanks very much, Jim. I'm now going to ask the accident benefits specialist in our 2 office some questions. And Loretta, I'll start with you. What is it, Loretta, when you receive an occupational therapist report that you look for and that you like to see in such a report?
With respect to having a client deemed CAT, John, I'd like to see an OT go into a lot of detail with respect to the client's function. I think everybody's reiterated here that it's very important to speak to the family and the family members. It's great if they can give actual examples as to how certain people are affected. For instance, if the father no longer goes to a child's basketball game because he doesn't act appropriately, or the noise affects his behavior, those are comments to make. Speak to the kids. I have reports where the kids talk about having to walk on eggshells because the dad is going to explode if they make any noise that he isn't used to. So those types of deals are those types of details are very, very important for us when we're trying to assess that. If we don't have an updated report when we're about to send a client for a CAT assessment, we will have an OT come in and do an updated report so that they could address the physical, emotional, and cognitive function of the clients. They become a very, very large part of the CAT process itself, and quite often the thing that the IE assessors miss out on. And if you'll recall, John, on the Mutharaj decision, the IE assessors were criticized for not speaking to the family members and getting more details as to how the family was functioning. So those are the type of things we like to see.
Kimberly, what is it you like to see in an occupational therapist report when it comes to the issue of catastrophic impairment?
Well, I would agree with everything that Loretta has just said. OTs have a significant role in assessing and documenting the ongoing difficulties that clients have with respect to physical, psychological, emotional, and cognitive functional abilities and limitations. It's helpful not only to have the in-home assessment, but I think it's absolutely critical that we do an updated in-community assessment. We want to see how the clients are functioning in the community. How are they doing with their banking? How are they able to cope with a simple shopping trip for some groceries? How are they reacting to other individuals within the community? An advantage that OTs have over other therapists, simply due to the nature of their involvement, is that they get a true picture of the family dynamic. They can see the relationships within that home and see how they've evolved and how any impairments have affected those relationships, and simply document all of those things. Family accounts are very valuable information. If there was a return to work plan or a return to work effort that had failed, we want you to document that. Speak with the coworkers, visit the employer, find out what the issues were, and put all of that within your report. We're seeing now that arbitrators and assessors are acknowledging the synergistic nature and elements and effects of the impairments. One impairment on their own might be very mild in nature, but when you combine them all together as a whole, it can result in the catastrophic impairment. So just to ensure that progress reports are kept very up to date and all of that information is included.
Thank you very much, Kimberly. Troy, I've got a question for you. Are emails that a treating health professional sends to their patient or to the lawyer, are there any concerns that you have about such emails?
I do. First of all, they do form part of the clinical notes and records. Defense lawyers will invariably request them, and they will be produced in the lawsuit. And more often, we're seeing a lot of volume with respect to emails, so there's a lot to go through. And there's a couple of things that I've noticed about them. One, people tend to speak in a much more informal way in an email than they would in a report. It's something about email that does that. I don't know what. But we see people, treating professionals, saying things that we know they wouldn't say in a report, in an email. The other thing we see is something I talked about earlier, the commentary that's not relevant to treatment, or comments that go outside of the treating provider's area of expertise are often found in emails, both to the patient and to the team. So you have to be careful when you're writing an email. Treat email like you'd treat a report to the insurance company.
Thanks, Troy. Jim, here's one of the questions I have from someone listening in, and sounds like this person has been into court before. When we go into court with summary notes related to having reviewed the file, and the opposition takes your notes while on the stand, well, can we ask for them back since they were there to help us with a quick response to certain areas of the file?
Absolutely. You have to be careful with those summary notes. I'd like to suggest to people that I'm meeting with in preparing for their evidence that they not take notes of the meeting that I'm having with them, because they may write things down in such a way as to create a perception that I'm guiding their evidence, and I would never do that. So absolutely you should ask for those notes back, and at no time should the defense have them and you not. They're entitled to have them, to review them. They should immediately give them back to you as you're testifying.
Thank you, Jim. Pat, here's one for you. If a family member of an injured person is unemployed and is searching for a job and puts his job search on hold to provide attendant care, do you think that putting that job search on hold is enough to constitute an economic loss under the SABs? And a second part of that question, what happens, Pat, if the insurance company refuses to pay that person and he or she is forced to go back to work, thereby eliminating any economic loss argument?
On the first part of that, John, with the person unemployed, and I think, and as I've indicated in the Simsters case, you're going to need evidence. So I do think it is an economic loss, but you would have to show evidence that he in fact had a job offer available to him, and obviously produce the letter. The alternative to that would be to call perhaps a vocational assessor to establish that a job would have been available for that person if they did not choose to provide the attendant care services. So one of the two would have to be obviously established by evidence to support it, but I do think it's an economic loss. If the insurance company does not pay, which I think was the second part of your question, but the person is returned to work, would they still be entitled to that attendant care? If you establish the proper evidence and you establish it, obviously it was an incurred expense that the insurance company ought to pay and they just simply did not, and then I think the whole rationale that came out in the McMichael decision would be applicable to that, and from a policy perspective, they ought to pay for the attendant care services.
Okay, thank you. Kimberly, here's one for you. Is it okay for a treating occupational therapist to attend an insure examination in-home assessment?
I think, John, we would have to address those on a case-by-case basis. There are times when clients are so significantly impaired or really lack insight, they aren't able to actually properly address the questions given by IE assessors, or they're not able to acknowledge their true impairments or limitations. In those cases, we do request permission from the insurer and the assessor for the treating occupational therapist to attend. Even sometimes it's a social worker would attend. But again, it's really always on a case-by-case basis. Sometimes we don't want things to be misinterpreted or give the impression that our treating OT is really trying to take over the assessment.
Loretta, if the treating OT asks for permission from the insurer examination assessor and it's refused, what are the options?
Well, they wouldn't be able to attend. I mean, the IE assessor is entitled to an impartial assessment. They could be present in the home if the family wanted them there, but they would have to leave the room and allow the IE assessment to take place.
Okay. Okay, Jimmy, here is one for you. If I have to go to court as a treating witness, do I need to read anything other than my own chart?
Well, that's a difficult question to answer. Sometimes treating witnesses will be asked questions about other expert opinions, and to the extent in cross-examination they are asked about others' expert opinions, if they have not read them, they may feel uncomfortable giving a response. On the other hand, a treating witness is often asked to testify not so much for their opinion in the litigation, but just in terms of what treatment is being provided, what their diagnosis is and prognosis is in respect to treatment. And to express that opinion, they no longer have to prepare a report. It would appear from recent case law. So it's a bit of a double-edged sword, because if the treating witness is just going to testify about treatment and his opinion or her opinion, and it doesn't matter what he or she thinks of somebody else's opinion, and then they need not have their opinion. But I would err on the side of caution and at least have that witness prepared to say, I know that that's what the other expert says, I just don't agree with it, and I didn't agree with it in the course of my treatment.
Troy, here's one for you. In terms of how a health care provider gives evidence at a trial, is there a difference between a judge alone trial and a jury trial in terms of how that health professional gives evidence?
There is. Although you should never assume that a judge knows a whole lot about medicine. They've obviously heard a lot of cases and will have a higher level of experience than most jurors. But you really have to be a teacher, both with a jury and with a judge. You shouldn't assume that a judge knows a whole lot about the area that you know a whole lot about. The judge will look to be educated just like a jury would. And you should be careful about using a whole lot of medical jargon without an explanation, particularly with a jury, but I think even without a jury as well.
Thank you. Here's a question that I've received. Pat, I'll let you deal with this one. It's been mentioned that occupational therapists are in an ideal position, more so than other therapists, to see the family dynamics. As a social worker who goes into a client's home weekly, bi-weekly, or whatever the arrangement may be, in order to provide counseling and observe and monitor the client and family dynamics directly, I believe that the role of the social worker and value of the social worker cannot be overlooked. What are your thoughts?
I agree.
Good question.
I agree. I think for any individual, especially treating practitioners, OTs, speech language, social workers, they're all a window as to what's happening to an individual within their family environment. And not all families have certain dynamics where we're able to extract that information, and at times the injured person, because of their impairment, can't give us the information we need to understand what's going on. But certainly treating practitioners, social workers, OT, speech language, RSWs, PSWs, all are observing what that individual is doing. And as we've already found out, these are critical pieces of evidence in establishing marked impairment as well as what's happening to the individual. So I think it's absolutely critical. And again, it goes back to the whole note-taking, is to make sure that you make proper note-taking of incidents that you do see where there's safety concerns or behavior that's erratic that would require perhaps attendant care or whatever the issue is at.
John, can I just chime in on that as well? I agree 100% with Pat. Trial is like putting pieces of a puzzle together. And an OT is critically important in terms of putting his or her observations before the jury, usually, about how the impairments are affecting them in the community. But each of the disciplines that Pat has referred to, the RSWs, the social workers, the physiotherapists, the counselors, they all come at it from unique perspectives. And to the extent that there's a convergence of the evidence and of their observations, all of that sameness goes to the jury, and it's much more important for them to receive that information than it is to have expert opinions. The high and mighty ivory tower defense doctors who often say, well, there's no real significant impairments, that's just part of life. Oftentimes, and I know we've talked about this a lot at the lawyers between McLeish, Orlando, and us, the most important people at the trial, it's not the plaintiff, it's not the doctors, but it's the people in the med rehab community that are meeting with these people on a day-to-day, weekly, monthly, but at least a regular basis.
Thanks, Jim. Here's a very good question that does come up an awful lot. What do you think of the impact or potential impact of the client's social media in the decision of catastrophic impairment? I guess put another way, what are the implications of Facebook? Troy, why don't you start with that one?
Sure. We're seeing it more and more often. When we go to a discovery on just about any case, the defense lawyer will be asking our client, do you use Facebook? Do you use Twitter? And if the answer is yes, then the next question is we need a copy of it, and we need you to preserve that. And we've argued motions over it. And in many cases, the Facebook has been produced. And if you think of marked impairment as an example, one of the areas of function that is being looked at with respect to marked impairment is social function. And if you've got your assessors saying the person has almost no social function, meets the test for marked impairment, and there's a Facebook account with pictures of them doing all sorts of social activities. And it doesn't just have to be on their Facebook account. It could be posted on Friends, tagging them in pictures. You can see how that evidence is going to be a serious problem with respect to establishing that person is catastrophically impaired on the basis of a marked impairment.
Anything wrong, Troy, with it at some, or Pat, say Pat, just ask him to delete all their Facebook information?
Do you ask him to delete it?
Anything wrong with that?
I think how I approach that, John, is I simply indicate to them Twitter, Facebook, all that that's on the web is going to be viewed by individuals, defense lawyers, insurance companies, with the whole intention of going through it in order to pick out things in order to reduce or somehow limit the person's entitlement or claim, and therefore to take that into consideration when they're continuing to use that type of media. I don't tell them to delete it, but I certainly tell them the implications of their continued usage of it. And it can be at times devastating. I find a lot of people in social media try to certainly portray themselves as something that perhaps they're not. for whatever reason, and therefore it's not always an accurate picture of an individual for obvious reasons.
Can I just jump in on that, John, quickly?
Absolutely.
I don't think it's proper to tell them to delete it because it's evidence, but I think it's completely proper at the outset of the case to recommend that they stop using it. Get off of Facebook, Twitter, stop posting. There's absolutely nothing wrong with that. And so long as they listen to you, and they don't always, that eliminates the problem.
Yeah. Okay, here's one for you, Loretta. Whose responsibility is it to produce evidence for incurred expense? The treating health professional or the lawyer?
I would say the lawyer. Simply because I think that it's up to us to help the clients tweak out where they can have an incurred expense. I mean, sometimes you basically have to sit down with a family member and go through what their daily life is like. For instance, if you have an active parent with children who are driving them around to activities after school every day and they can no longer do it because they're at the hospital, I think it's up to us to help them tweak that out and give them some suggestions for assistance that will alleviate that stress so that they can spend more time with their injured family member. So yes, I would say it's our responsibility.
Okay. Kimberly, here's one for you. If an OCF 18 has been submitted but declined by the adjuster beyond his or her area of expertise, what is the time frame they have before sending the client for an IE to address whether the OCF 18 is reasonable and necessary?
That's actually an unfortunate situation that we are all too often seeing at this point. The insurer will respond within the appropriate time frame, the 10 business days, either accepting or denying the treatment plan, but then that time frame has now been removed for the limitation for when the IE has to take place. So unfortunately, we can be waiting months in some instances to get this IE underway and get a report back in our hands. And of course, whichever the result then would be, we would have to deal with accordingly. Should the dispute or denial be maintained, we would initiate a dispute on behalf of the client. But unfortunately, it is a situation that we do see with the time frame.
Is there anything you try and do to hurry up the process?
Absolutely. We would, send constant follow-ups, ask for an update on the status, on the scheduling, just constant reminders to the adjuster. We don't want things to just sit quietly. We let them know that they're, this time frame that they're taking is causing further implications to the client, that it's treatment that they need. So we give constant pushes along to try and speed that up.
Loretta, here's one for you. Now that there are no rebuttals, what is the best way to address concerns identified by the treating health professionals in the IE report?
We come across this a lot, John, because many treatment providers get quite upset that the IE assessors don't call them so that they can add any additional information, which is not always a bad thing. I think it's a good thing that the information that they want to provide to the IE assessor does not become part of the IE report. I will definitely ask the treatment provider to review the IE report and to send us their comments. Quite often they want to do reports themselves and send them directly to the insurer, but we do request reports even though they're not covered by rebuttal. We take on the responsibility.
Kimberly, you agree?
Yeah, absolutely. We've actually seen situations where the assessor has contacted the treating professional and have, seen things twisted with words, and comments have been misconstrued, and it actually comes out negatively for the client. So then we've got a whole new argument to take on.
Here's another submitted question. If there is no incurred expense or economic loss for attendant care, do the Form 1s have any other benefit to the client? Jim, why don't you field that one?
Yeah, they do, John. We are most often than not involved in a tort claim as well as helping them with their accident benefits, and clearly a form that says that even though the insurer is relieved of its obligation to provide full-time attendant care because the legislation requirements haven't been met, it doesn't relieve the tortfeasor of their responsibility to compensate for what the plaintiff's losses are, so we can use the Form 1s in the litigation.
Okay, Pat, here's one for you. I've been told that if there is no economic loss and the family hires a PSW to provide care, let's say attendant care, for a portion only of the time, the family will then have access to the full benefits given that a portion of the expense is incurred. Is that correct?
No. If there's no economic loss by the family member, then the family member will not be entitled to accessing the attendant care benefit. However, the PSW would fit within the definition and certainly be paid.
Okay. For clients in the community who are receiving the maximum attendant care benefit but not using the full benefit towards attendant care, is the adjuster within their right to withhold attendant care benefits and only pay out for the services that are being provided? Troy, why don't you take a shot at that one?
I think the answer is no. Once there's an economic loss in the Form 1, their obligation is to pay in accordance with the Form 1. The SABs are clear on that. We're seeing, and Kimberly, Loretta can address this, more and more often, insurance companies asking for a list of services that are provided by family members and trying to scale back the amount that's paid month to month, making that argument. But I don't think it's a correct argument based on the language of the SABs. I think their obligation is to pay the amount of the Form 1 when there's an economic loss. The Henry case is clear on that.
Kimberly, do you want to add anything to that?
I completely agree with what Troy has said. Once we've provided the information to support the economic loss, the SABs is quite clear in indicating that that benefit has to be paid based on the Form 1.
Okay. Loretta, here's one for you. Should recommendations for training programs be included in an assessment report, or just a list of recommended jobs based on education, training, experience, and
Sorry.
physical restrictions?
This is a vocational assessment report, John?
Says assessment report. It's either an OT report or a vocational report.
Should there be recommendations?
Should recommendations for training programs be included in an assessment report, or just a list of recommended jobs based on education, training, experience?
That's a tough question because I think I would have to see it in the context of the report. I mean, we definitely like to have recommendations in any assessments that are done by a treatment provider, but I would certainly hope that if they were making recommendations for a retraining, that it was in the context of their expertise.
Kimberly, what about this one? Should a treating OT initiate a Form 1 reassessment when a client has made significant functional gains and no longer requires the amount of attendant care initially determined?
I think certainly, within their profession, they're obligated to make note of any change. I think sometimes we do have to be careful with the amount of times, any kind of reassessment is put through. If there is some kind of indication that things should be changed or the amount of care should be a little lighter, we can certainly put that through and, keep in mind that, with a trial of further more independence and seeing how things go, that we can certainly always, take another reevaluation in the future if things weren't going as well for them based on that OT report.
Here's a very, very general question. I'll put it to you, Troy. Can you please talk a bit about tort claim reports?
So that's the expert report that I was talking about before, as opposed to the clinical notes and records. Whenever you're asked by a lawyer to deliver a medical legal report or a tort claim report, you're being asked to provide an opinion on an issue in the lawsuit. It could be, for example, an opinion to support an aspect of the long-term care plan. So in our office, when we get a long-term care plan in, we'll often send it out to members of the treating team, for example, a psychologist or a social worker, and ask them to provide a report for use in the tort claim to support the recommendations in the long-term care plan relating to counseling. And when you've received a request like that, it means that you're now in the system that's governed by Rule 53 of the Rules of Civil Procedure. And I'll just take you through what you need to include. You got to have your name, your address, your area of expertise, your qualifications, the instructions that you've been given need to be set out in the report, the nature of the opinion sought and the issue that it relates to, that needs to be set out in your report. You've got to set out your opinion, the reasons for your opinion, including all of your factual assumptions, the list of the documents that you've reviewed, and probably the most important thing is to remember is you need to set out the reasons for your opinion. It used to be that people would write reports with a little bit of factual history and then a statement of a pretty bald opinion. That doesn't fly anymore under the new rules with respect to these tort reports. They have to comply with Rule 53, and that's the starting point when you're drafting one for the first time, is to take a look at that rule.
Okay, here's another question, and I hope we get it all. I take notes during sessions, but it is very difficult to vet those notes while I am writing them. Is it appropriate or acceptable to rewrite notes before putting them in the file? Pat, why don't you take that one?
I don't think there's anything wrong with that. If you're taking notes during a session, you're vetting and you're putting your notes in your file, and I think it's just a mechanism that works for that individual. So I don't see anything wrong with it as long as the notes themselves are making it into the file in a timely manner and are not scripted at much later dates. It just seems to be a mechanism of making probably comprehensive notes that make sense to that individual and can be used at a later date to refresh their memory.
Okay.
Now, that just so you know, John, that's in reference, and certainly it's not subject to any college. I know that the regulated health professions have certain requirements for each regulated health professional as to the nature and extent of their note-taking and when they're to make those.
Okay, Jimmy, here's one for you. Can a CAT determination ever be reversed?
Well, a CAT determination, it's a hard question to answer depending upon what you mean by reversed. A CAT determination is only made by a judge or jury at the end of the day, and that can't be reversed. However, you can bring a subsequent application for catastrophic impairment if there's been a material change in condition, or you can also bring a subsequent application for catastrophic impairment based upon a different criteria. So if the first determination was whether that person had a marked impairment or not, and the answer was no, or there was a finding of no, you can subsequently, if there's been a change of condition that is material, say, well, I want to relitigate that. And even if there hasn't been a change in condition, you say, well, now I want to go under a 55% whole person impairment.
Okay. Kimberly and Loretta, I'm going to let you answer this next question. We have an adjuster who is being particularly difficult with approval for attendant care and various treatment for an elderly client. We did an attendant care assessment and recommended 24-hour care. The insurer is IEing it, but it has not been timely. The adjuster has not agreed for us to implement any PSW to date until she gets her IE. I feel she is obligated to allow the PSW at least until her IE says otherwise. Is this accurate? Kimberly, why don't you start?
Yeah, that's another situation, unfortunately, that we do run into at times. If there is any indication at all that the situation or the environment is unsafe for the client, we need to work together and assist with getting the insurance company to understand the need for that care to be put in place immediately. sometimes it does, they, very strict policy within the insurance company, and they won't give any kind of approval for services to be paid or put in place on their end before they have their report in hand. But what we would always encourage at that point is to make sure that the clients are well cared for. We don't want to leave anything open for any, risk of further injury or any situation. So we do encourage services to be put in place. We'll keep documentation to support any of the costs incurred, and we will then work with you to ensure that all of those payments are brought up to date once reports are put in place or the approval is given. But we will then, of course, continue to provide supporting documentation to have that care for the clients.
Loretta, do you have anything to add to that?
No, the only thing that I've tried that often works is I'll have the care providers call the adjuster and try to explain the need in the situation that the clients are in. And very often the adjusters will approve on a limited basis, pending the IE. As Kimberly said, it is difficult, and we do try to do what we can. And, sometimes we just have to work on protected account basis to ensure that they get the treatment that they need.
Okay, here's something. I don't know if it's the case or not. Here's the question. Although there was no formal deadline for insurers to perform insurer examinations anymore, the Market Conduct Department at Fisco has advised me that no more than 30 days is a reasonable time period. So that's the question. Is that the case, and is that an option for a delay of an insurer examination? Kimberly, why don't you?
I think if we have something, a letter of that sort that we could send to the insurer to support our position, that would be of excellent benefit. The other thing that we do is within those letters that we send to the insurance companies, letting them know of our position and encouraging them to hurry those assessments up. We will, cite actions in bad faith if they are unreasonably delaying or not pushing through certain IEs that are withholding benefits from clients.
Loretta, in that same vein, is there a insurer ombudsperson that can be any help in situations like that?
Sure. We often write to the insurance ombudsman reporting bad faith and undue delay on things in order to try and expedite things for clients. And they do take them quite seriously and will address those issues.
Okay, Troy, here's a question for you. A treating healthcare provider tries to be optimistic in team meetings and refers to positive gains made by the client. Trial or fiscal arbitration is coming up. How does that health professional deal with being cross-examined on the optimistic notations in the notes and probably the report?
Well, one way to deal with it is to explain the reason for the need to be optimistic in the team meeting when the client or patient is sitting across the table. A better way to deal with it is to be optimistic as you can be, to deal with that person's emotional issues at the team meeting, but draft your team meeting summary or your notes in a more balanced way. And it's fine to be optimistic with respect to certain areas, so long as you're balanced and realistic in the report. If you're overly optimistic in the report, that's going to be a problem on cross-examination, and it's going to end up hurting the case.
Can I just add something to that as well? Something that we like to see within those reports, if there are comments made of improvements, we like that you would add the reason for those improvements, and of course it's the treatment that you're providing, and as well then at the end say, if we don't continue with this treatment, this client is going to regress and we'll be back at square one. So just be sure to balance it out.
Pat, here's one for you. What happens if a health professional in his or her notes details conversations between a lawyer and the health professional and the patient?
Well, firstly, I would certainly recommend that any health professional not detail any notes in relation to conversations between the patient and their lawyer. We are afforded solicitor-client privilege, meaning that we are allowed to speak to our clients without being compelled to provide that information to anyone. And that is one thing that's available to all people who have lawsuits and have a solicitor or lawyer representing them. So from that standpoint, I wouldn't include that. If you have it inside your notes and we see it in your notes and there's reference to that conversation, then we will deal with it accordingly prior to perhaps trial or another event. I would not delete it or take it out. That could cause other problems. But certainly it's something that the lawyer will identify and speak to you about in advance of a trial or hearing, and then the lawyer will deal with it accordingly within the court system as to whether or not it can be excluded.
Okay, Jim, here's one for you. If an OCF 18 for a treatment provider in the community is denied, depriving the client of care, and it would be detrimental to the mental and physical health of the client, should a treating health professional go ahead and treat the client or wait until approval is granted? If a professional does treat, is there an obligation to pay on the part of the insurer?
I don't think there's an obligation to pay on the part of the insurer, number one. Number two, this is a great issue, and one that I think the treating professional should raise with counsel and or the accident benefit specialist. If our client's in need and has a tort claim, then most of the time the lawyers at McLeish Orlando and Oatley Vigman will undertake to pay the cost of the counseling or whatever it is, the service that's being provided. Certainly if to do so or to fail to do so would be detrimental to someone's psychological well-being in a significant way. It goes without saying. So I think, and there are, of course, other firms that will do that. So I think it's incumbent upon the law firm to work with the treating health professionals to see whether or not there is some way to make sure that the person doesn't suffer and the insured is getting the treatment that they need. And then we can always do the letters to the insurer saying why it's going to be harmful to their health and what the repercussions are in terms of a bad faith claim, things of that nature.
Okay, here's a question. Clients who have, and it's from a speech-language pathologist, clients who have a high level of skill use a variety of social media, i.e. texting, a message, Facebook, to communicate and remain involved in the community with friends and family. From an SLP perspective, I believe it is positive. It is difficult to see a negative or positive. This is an opportunity for the SLP to present how this is an opportunity, I don't quite get this. This is an opportunity for the SLP to present how this is positive and whether this is something the client does with or without support. Since clients can do some tasks, it does not mean they can actually do so on a regular basis unless coached. The SLP can interpret, educate the reader. So I guess to summarize in this speech-language pathologist's opinion, it's a positive to have the person using social media. Kimberly, do you want to comment on that?
I think we would have to take into consideration the comments that Troy had made about, the risks that could be posed with the impressions that the clients are giving to everyone outside using Facebook and social media. I think more in terms of the texting, I know that a lot of therapists use that with clients, working on those skills and communication pieces. It helps with some organization tasks as well, with communicating back and forth with their treatment providers through via text. But I think we would certainly have to pay heed to what Troy has commented on with respect to the social media as well.
Caution is the word of the day. Loretta, maybe you can handle this one. The minor injury guideline states that the patient is granted up to $3,500 in treatment, including medication expenses and other expenses related to motor vehicle accidents. In one of our cases, an adjuster approved the first 12 weeks of treatment at $2,200, however, denied the remainder, notwithstanding they submitted a plan for $1,300 and stated the patient was being sent for a insurer examination. This is the first time I've seen this where the remaining treatment is denied. Does the adjuster have the right to deny the remaining treatment? Loretta, do you have an answer on that one?
I would say that they do if they do their IE assessment. They have that right to deem it reasonably unnecessary or unreasonably unnecessary, and it would be up to us to dispute it.
It makes perfect sense, doesn't it, to spend $3,000 in IE when there's only $1,200 left?
I know. It's done, believe it
Yeah,
or not.
Yeah, yeah.
John, speaking of the MIG, I don't know, do you think that anyone in the audience might be interested in that recent decision on that?
Actually, that's a good point. Jim, why don't you just start talking about the case briefly, and then we can take some questions on it.
Okay. Scarlett and Bel Air, and it was a decision on a preliminary issue, and that's whether the person was in the MIG or not. And in this case, there was no question but that a person had suffered a soft tissue injury in the classical type, which would really keep them in the MIG. However, it was argued that in this case that the person had suffered other injuries that took him outside of the MIG, including a TMJ injury and psychological injuries, which included depression. And the arbitrator held in this case, and I think it's fair to say that he was fairly critical of the way the matter had been addressed by the legislature and by the insurer in this case, that they fell outside of the MIG, where you're partly in and partly out, you're out. And so that the evidence which was accepted was that chronic pain resulted from symptoms separate from soft tissue injuries, presenting as a psychological, neurocognitive, and emotional impairments, serious depressive symptoms, PTSD, and a TMJ issue. There was a finding that it was supported by some credible evidence, which consisted of medical reports that had been filed. So the insurer, the arbitrator rather, said that the insurer is in effect mandated to make an early determination of an insured's entitlement to treatment beyond the MIG. In essence, because of the necessarily early stage of the claim when the MIG is applied, the determination must be an interim one that is open to review as more information becomes available. And they held that in this case, the insurer had not discharged its onus. It's the insurer's onus, because the MIG is an exception to the general rule. The insurer has not fulfilled its obligation to the arbitrator to establish that the case fell within the minor injury guidelines.
Pat, are you prepared to comment on that case?
I think Jim did an excellent outline. I agree that the onus is on the insurance company as it relates to MIGs. Remember, MIG was put in minor injury guidelines were put in for minor injuries. It wasn't meant to take care of chronic pain conditions, which can be very disabling. TMJs, depending on the medical evidence, can be extremely disabling. And so if you have credible medical evidence that suggests somebody has chronic pain, TMJ, depression, these things ought to be taken outside of the MIG. There was a specific provision saying that if you have a pre-existing condition that will limit your medical recovery, then that was something that was implemented within the legislation. So from that standpoint, I think it's a good decision. And I think that the specific exception that was put into the legislation was used for this case, and it was meant to be used in this way.
If I can just comment, another thing that case says in paragraph 68 of the case, it makes no sense if the insurer is positioned to veto access to benefits on the basis of delivery of a single report. in the face of credible evidence to the contrary, when the resulting delay in treatment could last for years. This runs contrary both to the spirit of the accident benefit scheme and the stated purpose of the guideline itself. So I think that's important, and as been said, the purpose of the guideline is to provide people with quick, early, and limited intervention to assist in recovery, and that decision should be made on the basis of credible medical evidence and not speculation. And you recall the MIG guideline itself refers to compelling medical evidence with respect to a pre-existing impairment. Well, this case seems to interpret compelling as credible. So, as Jim said, the insurer was not chastised, but they're denied based on one insurer examination was not found to be appropriate, and the person was taken outside of the MIG. Anyone else want to say anything about that case? Troy, do you have anything to add about it, or?
About the MIG generally, I can tell you about a case that I dealt with where we really relied on an occupational therapist to help get us out of the MIG. It's a man who had what may have appeared to the insurer to be a minor injury early on, but tried to go back to work and struggled with cognition and problems consistent with a mild brain injury. And insurer had cut off treatment based on the MIG. We spoke to the occupational therapist, got a report setting out those issues and the struggles this man had with function, and then provided that report to the treating doctor to get some credible evidence, which ended up getting him out of the MIG without a judicial determination. The insurer, once it had that information, rolled over on the issue, and that man is now about to be declared catastrophically impaired. So some people with significant issues can get into the MIG early on, and the treatment people with good reports can really help us get people out of that system.
John,
Okay,
I just
go ahead,
add
Pat. Yep.
One thing, certainly after this decision was released, I think we've all heard that there's a fear that it was somehow going to open the floodgates to people getting outside of the MIG. And I certainly didn't read the case that way, and I certainly don't think it's going to have that necessary impact. It's dealing with an exception, and I think Arbitrator Wilson, when I looked at the decision, said you can't use this cookie-cuttered approach on every soft tissue case, but you do have to take a look at individuals. And I think if you look at certain individuals, there is a smaller percentage that don't recover in the same way as other individuals do. And it's this exception that it was for, and I certainly don't read it as opening the floodgates as some have indicated.
Thank you.
John, if I could, I've got a question from an occupational therapist that does great work, and she says this, and maybe I can throw it out to you, John. I believe OTs are key players through medical legal assessments in helping the lawyer reach the pain threshold for soft tissue injuries in the tort claim by trying to help demonstrate permanent and serious functional impairment in physical, mental, and psychological domains. We've seen a recent increase in interest in this regard and would find it most interesting. Do you have any experience with this?
That is a very good question. Remember the threshold, the permanent and serious impairment threshold has been defined by regulation, and there's basically three areas that come into play in meeting that threshold. And I'm paraphrasing, this is the language we use in our office. One is with respect to work or employment. The other is with respect to a training program or education, and the other is with respect to activities of daily living. So if the person is having difficulty in one of those three areas. Those are the areas to concentrate on. Can an OT be useful? Absolutely, yes, if they deal with the person's work or the person's ability to train or become educated or their activities of daily living, but not exclusively an occupational therapist. An occupational therapist is certainly a key player, but we want, just as there's a treating team, I mean, we want input from all the treating health professionals to the extent that it's within their sphere of expertise to comment on those areas. So yes, an OT is helpful, but not to the exclusion of others would be my thoughts, Jim. Anyone else want to comment on that at all? No? Okay. There's a lot of questions about person's clinical notes and records, so here's a combination of some questions. Can I shred my notes as soon as I do a progress report? And as part of that, I've been using a computer to take notes for the last month or so. If asked to present these notes in court, can I simply print them out and sign them? Are there disadvantages to using a computer? Troy, why don't you just talk about the issue of taking notes and keeping them and what you can and can't do with them?
Each of the healthcare colleges has requirements with respect to clinical note-taking, so you should be familiar with your own college's requirements. I don't think it would be proper to shred your handwritten notes. I think you've got to keep those as part of your clinical notes and records. It's perfectly appropriate to keep records electronically. More and more people are doing that. There's nothing wrong with it. There are requirements that the colleges have with respect to technical matters that go beyond my level of technical savvy in terms of backing things up. So you need to be familiar with those requirements. And if you keep your notes electronically, printing them off and providing them to counsel when they're requested, and the printed copies, that'll be your chart at a trial, and that's often a lot better than a handwritten note because it's going to be legible and may well be more complete.
John, I'm going to add one thing to that on that particular. In June of this year, they're coming out with the new regulations regarding fraud prevention. And one of those is an insurer can demand a service provider confirm in writing that they provided the service. But in addition, there's also an indication they can also require a statutory declaration giving rise to the invoicing for the service, and that information has to be provided. And it has some implications on interest for unpaid invoices. So if anything, too, with note-taking, just an added thing of the importance of having notes if you are providing services to an individual, just in case these types of demands are made in the future.
And just if there's any doubt about it, in every single case we do, every single case without exception, the defense lawyers ask for clinical notes and records, and not just once. They'll ask for updates. So you just cannot beat detailed and comprehensive notes. And the optimism in front of the parents or the patient with meetings is fine, and it's just fine to document that in notes as long as you're realistic. Yes, the person's memory might be improving but from where it was, but they can still have huge difficulties with it, and they may have other problems with balance or focus or concentration or multitasking. So yes, mention the good, but please dig out where the deficits are from the clients. I think every person on this panel would say that clients can be their own worst enemies because they're not good historians when it comes to their ongoing symptoms, and a lot of them, as we all know, are in denial. They just don't want to admit it to themselves, or they truly haven't been tested. So we all of us here just can't say enough about good and comprehensive note taking. Pat, here's one for you. It has to do with incurred expense. Before an accident, a mother normally helps her children with their homework. Her husband is injured in a motor vehicle collision. After the accident, she provides attendant care to her husband. She no longer has the time or energy to help her children with their homework. She hires a tutor. Does this qualify as an incurred expense so that the mother is entitled to the attendant care benefit?
I take it if she hires a tutor, she pays for a tutor. If she pays for a tutor, it's akin to an economic loss. And as long as they properly document it with the invoicing, obviously the payment to the tutor, then it's certainly something that would be, I would think, an incurred expense and considered an economic loss.
Okay, a related question, Troy, for you. Before an accident, a wife is a stay-at-home mom and a full-time homemaker. Her husband is injured in a motor vehicle collision. She provides attendant care to her husband. She no longer has the time or energy to do her housework, so she hires a cleaning lady 1 day a week at a cost of $75 a day. Does the cost of the cleaning lady qualify as an incurred expense, so the mother is eligible for the attendant care benefit?
I think the answer is yes, and the analysis is the same as Pat just described. It's an economic loss. It's not as much as the Form 1 likely is, but once you have any economic loss, the obligation is to pay the attendant care pursuant to the Form 1. So it is an economic loss, in my view, an incurred expense, and the attendant care should be paid in that situation.
Kimberly, in situations like that where the expense that is being incurred is far less than, say, the actual attendant care requirement, how are you faring with insurance adjusters?
Across the board, really, we aren't finding any kind of consistency with insurance companies. It's almost on a case-by-case basis as adjusters are handling these situations. But the approach that we take is once we've proven that there's been an economic loss, we can support that. We're quite successful with getting the attendant care benefit paid based on the Form 1. We just have to be providing very clear documentation and just continue to be creative with that.
Okay, we've just got a few more minutes here. Loretta, here's one for you. If you've got a really hard-nosed adjuster and they're not paying the medical rehab and they're not paying what they should be doing, is there something you can do for that injured individual who needs services?
Certainly, John. I encourage the OTs to go outside of the insurance industry, get in contact with CCAC, help clients get Meals on Wheels. There are lots of government-funded programs within individual communities that do have treatment available to clients and funding available. So, many times we have to go that route while we're waiting for clients to either be deemed CAT or to have treatment plans approved.
Kimberly, as follow-up to that, what are some of the government-funded programs that are available to some of these individuals?
Well, we can get in-home attendant care through CCAC. We can access Meals on Wheels. There's community transportation services through Red Cross. The March of Dimes has always been a great help to us with accessing community resources for clients.
Okay, thank you very much. Our time is up. Just before we close, I'd just like to tell everyone that the next webinar that we plan to hold is going to be on October 29th at the same time, 9 a.m. And I want to thank the panelists. Everyone worked hard and prepared for this. And if you do want material or you have any unanswered questions, I think virtually every person on this panel would be happy to handle them as best we can. So that's it. Thank you very much for attending.